This video is for general information and commentary. It is not legal advice. In court cases, allegations are claims that must be proven, and they are disputed by the other side. Prince Harry is back in London's High Court, and this isn't just royal drama. It's a privacy case about how information is gathered, and whether a major publisher can be held responsible for unlawful methods. In the next 10 minutes, I'll explain who is suing, what they allege, what the publisher denies, what the judge will decide, and what to watch next. The defendant is Associated Newspapers Limited, often called ANL. They publish the Daily Mail, the Mail on Sunday, and MailOnline. The claimants are 7 people, including Prince Harry. They also include Elton John and David Furnish, Elizabeth Hurley, Sadie Frost, Doreen Lawrence, and former British MP Simon Hughes. Their claim is that unlawful information gathering was used against them, and that it fed into media coverage. Associated Newspapers denies the allegations. They say the claims are baseless, and they dispute that illegal tactics were used. Here's the key point. This case is not about whether you like Prince Harry. It's about evidence and where the legal line sits. The claimants allege that private investigators were used to obtain private information unlawfully, and they say that information was then used in stories. The allegations usually fall into 3 buckets. Bucket 1, voicemail interception, often described as phone hacking, meaning someone accessed private voicemails without permission. Bucket 2, illegal phone tapping or bugging. In simple terms, intercepting communications beyond what the law allows. Bucket 3, blagging. Blagging means obtaining confidential information by deception. For example, impersonating someone or tricking an employee into handing over private records. They say these methods were used over a long period of time, and they argue the publisher is legally responsible for what happened. And again, these are allegations. They are disputed, and the court will test them. This case matters because it sits inside a much bigger story in the UK. Privacy versus the press. Years ago, Britain faced a major phone hacking scandal that changed public expectations about journalism. This trial puts the Daily Mail's publisher under direct legal scrutiny on accusations of unlawful information gathering. A trial also creates something powerful, a record. Documents, testimony, and findings that can reshape how newsrooms work and how future cases are fought. Before cases like this reach trial, there are years of procedural battles. One big issue is timing. In many civil claims, there's a limitation period, a window of time when you must sue. Publishers often argue, the claims are too old. Claimants often respond, we couldn't reasonably have known the full picture until later, and the case should still be allowed to proceed. Another huge issue is scope. Judges often narrow cases so they don't become a giant inquiry into an entire era of journalism. So instead of, was the press bad in general? The question becomes, in these specific examples, what does the evidence show? That is why trials like this can feel slow. Here's what the judge must decide. First, did unlawful information gathering happen in relation to these claimants? Second, is there evidence linking that alleged conduct to the stories in question? Third, if unlawful methods were used, is the defendant legally responsible for them? This is a judge-only trial, so it will likely come down to documents, consistency, and credibility. Think of it like this. The court isn't grading vibes, it's weighing proof. Evidence in cases like this usually comes in 2 forms. 1, documents. Emails, invoices, notes, records, and anything that shows how information moved from an investigator to a newsroom to a published story. 2, witnesses. People testifying about what they did, what they saw, and what they understood at the time. The defense will argue the reporting was lawful and that certain witnesses are unreliable. The claimants will argue there is a pattern and that the documentary record supports it. So the case becomes a test of what can you prove and what can you connect. In a case like this, credibility becomes the drama. If witnesses contradict themselves, that matters. If documents don't match a narrative, that matters. That is why cross-examination is so important. It's not about shouting. it's about pressure testing details. So, what should you watch for as this trial unfolds? Number 1, which specific articles the court focuses on. Number 2, whether the judge accepts broad pattern arguments or demands story-by-story proof. Number 3, what the documents show, especially any records connecting investigators, information, and publication. And number 4, how the judge assesses key witnesses under cross-examination. Whatever you think of Prince Harry as a public figure, this case raises a bigger question about privacy, journalism, and accountability. If you want, I can make a part 2 breaking down the key terms you keep hearing, blagging, limitation periods, and how evidence works in cases like this.